I'm very honored to introduce our first speaker for this morning, Professor Francisco Xavier Ansuátegui Roig, who is a professor from Charles III University of Madrid. His research and publications focus on the philosophy of law, theory of law, and human rights. He has been involved in significant academic projects such as the History of Fundamental Rights, a comprehensive multi-volume work directed alongside other distinguished scholars. He also edits several journals, actively engaged in various academic and editorial activities. So thank you for coming, and floor is yours.
Thank you. Well, good morning to all of you. First of all, I would like to thank Professor Massimo Latorre and Indrek Grover their kind invitation to this conference. For me, it's a real honor to be here it's my first time in Tallinn. It's an honor to be here in the University of Tallinn. I will speak about technology and new normativities. And my speech is included in this third session, Rights, Democracy, and Machines, but I am aware that due to the perspective in which I am going to place myself, it could also be included in the first session. I apologize for this, because the basic problem to which I wish to refer is the position of individual autonomy in a model characterized by the presence of new normativities. Depending on the greater or lesser operability that we recognize to individual autonomy in relation to the law and to social organization, we will characterize different political models more or less democratic. It could be said that, in fact, democracy is a problem of majorities and minorities, and that, therefore, the position in which the individual is placed in the face of the new normativities does not directly affect to democracy. But, however, to speak of democracy also implies handling a certain idea of individual, or rather of citizen, who demands that his critical capacity with respect to normativity be recognized. For this reason, thinking about technology and the new normativities and about the space that is specifically recognized for individual decisions within the framework of these normativities is, in a way, something previous to thinking about the greater or lesser compatibility between technology and democracy. Usually, the transformations that law undergoes as a result of technology are focused on aspects that have to do, for example, with predictive justice, and from that point on the transformation of the functions and methods that judges and lawyers adopt in their work. But my point of view is somewhat different. I am interested in considering what is the conception of the citizen that derives from a certain way of conceiving and articulating the law. In 1965, Martin Heidegger gave a lecture in which he asked himself whether cybernetics meant the end of philosophy. His conclusion was that philosophy became superfluous since the mutation of the thing of thought implied the transformation of that thought and of the determination of that thing. Thus, the mutation of reality as a consequence of technology meant that philosophy, as a reflection on that reality, was also transformed and replaced by cybernetics. Well, Heidegger's approach at this point is useful for me as a starting point. A similar reasoning is the one I am trying to develop when I ask myself to what extent the transformation of normativity through technology allows us to continue talking about law. It is true that today we speak of post-politics, post-democracy, and also of post-law. When we deal with the overcoming of politics, democracy, and law, we find a multiplicity of elements. Well, my intention is to analyze briefly in what sense some aspects of technology can certify the end or the death of law. In other words, the end of a certain understanding of it. Because the truth is that certain dimensions of new normativities facilitated by technological development sometimes reveal us a law that is very different from the one we were used to dealing with. In its relationship with society and with the context in which it develops, which today has an evident technological dimension, law and legal science has constantly proceeded to a reformulation of its concepts and categories. But what is peculiar about this reformulation in the context of contemporary relationship between law and technology is that it does not only affect internal aspects of law, but the very meaning of law itself. The previous reformulations maintained the meaning of law, but today we are asking ourselves about what we are asking ourselves about is the very meaning of law. Do the regulatory strategies in which technology allows us to think about enable us to continue thinking about law as we thought about it up to now? This is a question we need to consider. This is why it makes sense to think about a hypothetical death of law. Let us think, for example, about the Dworkinian critique to the model of rules that identify norms with a fact and a legal consequence. For some people, this model fell into crisis with the alternative of principles, but no one thought that a model of principles placed us outside the law. Dworkin versus Hart was not considered the death of law. Now we are facing transformations that affect traditional categories to the point that we are asking ourselves to what extent we can continue speaking of law. Herein lies the interest of this reflection. In short, we are considering the problem of the limits of law, an issue that is fully within the scope of the thematic interests of the philosophy of law. We are thinking about limits, for example, when we analyze the contrast between the way of understanding law on the part of jus naturalism and versus that of positivism, if I may generalize. The problem that arises in this case is whether we can continue speaking of law in the presence or absence of certain contents. But the problem posed by technology is different. It is not a problem of the contents of law from a material or substantial point of view. What we are now asking ourselves about is whether certain regulatory structures can still be considered legal, despite the fact that it seems difficult to identify certain modes of functioning in them, which up to now have allowed us recognize the law. In other words, the perspective of analysis has to do with the reflection of the presence of a certain formal and structural limits. The philosophy of law deals with the limits of law, as I said. This implies having a concept of law which situates it in the sphere of normativity and which make it possible to establish differences and coincidences with other normative systems. But the philosophy of law has to deal with other problems, at least as important as that of the conceptualization of law. I am referring to the justification of the existence of law. This task implies different reasons in favor of resorts to legal norms to manage the coexistence of individuals within human groups. Well, technology directly affects these two issues, the concept of law and the justification of its existence. The technological context makes it possible to think about proposals to manage this coexistence which are different from law, at least as we have known it up to now. In fact, when we ask ourselves about the death of law, we are facing an issue that is not new. The prognosis alternate between the confirmation of the crisis of law and the confirmation of its death. In May 1951, the crisis of law was discussed in the University of Padua in Italy on an occasion in which explicitly were considered the death of law. In a very different context, in 1986, Owen Fish also wondered about the death of law. This time, the enemies were critical legal studies and the law and economics movement. Both distorted the objectives of law and endangered its very existence, as Owen Fish said. However, when speaking of the crisis of law today, there are other proposals that deserve to be taken into account. I am referring to those that rise as a fundamental issue, the replacement or the substitution of law by technology. Or, if one prefers, being less radical, the reformulation of the operability of law as a consequence of the expansion of the possibilities of technology in the management of the regulation of human conduct. Specifically, the basic thesis is that a model of law based on the establishment of models of conduct to which the citizen can adjust their behavior or not loses interest as soon as it tends to be replaced by modern technologies, which function as regulatory instruments in a context which technological management replaces traditional legal rules. The problem of traditional lawyers is that they assume that rules and norms are the exclusive pieces of social order. It is necessary to rethink the role of the theory and philosophy of law and of the rules themselves, since technological management is now concurring with the law, with the religion, and with the morality as one of the main instruments of social control. Thus, the current context invites us to think of a model in which new technology offers regulatory tools that make it possible to overcome the deficits of traditional legal rules. Traditionally, law has implemented a regulatory strategy by establishing models of conduct in relation to which people adjust or not their behaviors. Legal rules can be violated, and then the conflict, the resolution of which is one of the objectives of the law, is thus re-emerging. But technology makes conflict impossible. Illegal acts become impossible. What was once illegal but possible now remains illegal but is no longer possible. Law becomes redundant. As Professor Roger Wordsworth points out, prescription and prohibition were replaced by impossibility. we are in the presence of strategies to regulate human behavior that we can consider new normativities. Thus, the new normativity has a technocratic dimension. In contrast to the traditional assertion that there must be a rule designed to regulate a problem, the aim now is to look for a technological solution that avoids the problem by making it impossible. All this invites us to reimagine the law. The issue that arises is whether we are in fact facing an announcement or even a confirmation of the death of law. Thus, it has been rightly pointed out that the basic issue is the possibility of speaking of a post-legal state of society. In fact, we are facing with strategies that rely more on preventive measures than on punitive ones, and that invite us to think about a model in which necessarily, as a consequence of the impossibility of the wrongdoing, which is avoided by resorting to management techniques, resource to the intervention of the judge becomes exceptional. In this way, the pathologies of law, many of which have to do with its litigiousness, are reduced. In short, a law without specific conflict resolution mechanism, without adjudication, as Professor Lucy has pointed out, is thus conceivable. The elimination of conflict has important consequences for the understanding of the structure and functioning of law. Conflict and scarcity, considered as features of human groups, have a remarkable justifying nature for the very existence of law. The argument that in a situation without scarcity would not make sense thinking about the hypothetical conflict, neither in law nor in justice, is a classic argument that we find in authors as diverse like Miguel de Cervantes, David Hume, or Karl Marx. The elimination of the conflict leads us to the disappearance of the judge, who in modern legal experience is understood as the impartial third party that resolves the conflict. A law that cannot be breached because it is impossible to do so is a law in which the judge does not seem necessary. This implies a very profound transformation in our understanding of law. In the field of the theory and philosophy of law, different theories have defended different approaches in relationship to the judge, granting him more or less protagonism and responsibilities in the determination of what is law. We can consider the contrast between legal formalism and legal realism. What is certain, what is true, is that none of these approaches has considered the disappearance of the judge, regardless of the fact that in some cases, legal formalism has reduced his role to the aseptic translation to the law created by the legislator to the concrete case. Without the conflict derived from the violation of the norm, the new normativity is a perfect normativity. Here, perfection does not have to do with the content of what is prescribed, but with its capacity to ensure that citizens adapt their behavior to the model of conduct prescribed by the norm. Because in relation to the content, the technological context does not prevent us from recognizing that, on the one hand, technology is not neutral. And in the other hand, that there is a practical link between technology and power. The problem of the characterization of this power, whose opacity responds to the criteria of the neoliberal model of law, it's another matter. But this gives rise to problems related to the democratic legitimacy of this power, which I cannot go into on this occasion, and which must be taken into account in an analysis of the relationship between technology and democracy. I limit myself to recalling the complex relationship between algorithm and democracy as a consequence of the hidden nature of the power behind the opacity of the algorithm. Today, the decisions made by a small fraction of humanity, often difficult to identify, directly or indirectly condition the whole of humanity. This allows us to think about the effective existence of arcana imperii with a renewed potential and also with a new configuration. From the moment what is due becomes the only possibility, and when disobeying the norm becomes impossible, the perfection of normativity, I mean its total efficacy, will not therefore depend on the meaning of what is prescribed, but on the impossibility for the citizen to opposite this norm. The perfection of normativity is not related to its goodness, but to its incontestability. Furthermore, one of the challenges set out by the new regulations is to ensure compatibility between technological management and the requirements of the rule of law. What is true is that, for example, the fact that technological possibilities make it possible to dispense with general rules when regulating human life, resorting to micro-directives that apply to specific individuals in specific and particular circumstances, it is not merely an alternative to law. It would mean its death. Anyway, we are facing a scenario in which basic legal philosophical problems are being reconsidered, and their consequences go far beyond those derived from the configuration of a typology of regulatory solutions. The resource to management strategies and the conversion of the illicit into the impossible invites us to rethinking the relationship between the models of regulation of human behavior, among which law played a leading role up to now, and freedom, and human freedom. It comes down not only to the problem of the efficacy or inefficacy of models of behavior, but also to the problem of obedience to law. Evidently, if lawful behaviors are the only possible ones, the law will be effective by definition. Thus, one of the problems traditionally set out by the sociology of law and the philosophy of law, that of the efficacy of law, tend to lose relevance. The sphere of law is that of freedom. This is something that, as we know, Kelsen emphasized when he differentiates between the laws of nature and human norms. And when he established in the first ones the operability of the relation of necessary causality, and in the last ones that of imputation or retribution. The relation of necessary causality between the condition of application and the consequence excludes the possibility that reality contradicts what is foreseen in the norm. This makes it difficult to consider these natural laws as real norms, at least in the same sense in which we speak of norms when we refer to legal norms or moral norms. On the contrary, human rules are those in which non-compliance in effectiveness is possible, since it depends on an individual decision, regardless of the reasons that explain and justify such non-compliance. This is why the justification of obedience or disobedience to law is an issue addressed by the philosophy of law, which the resource to management strategies become irrelevant. The effects of the individual decision regarding the mandate of the rule lose importance, since the individual, in a certain circumstance, will not have the possibility of making a decision for or against that rule. This raises the problem of the moral agency of the individual. The ethical problem tends to disappear for the individual, since it only occurs when the subject is faced with the possibility of choosing between different alternatives on the basis of values. We are in the presence of a technological solutionism in which citizens are rescued from numerous burdens, offering them an easy life, getting more, faster and cheaper, apparently even a possible substitution of the tiresome task of deciding in freedom. The vindication of the moral value of the law, its consideration as a sign of civilizing process or progress, consists on the fact that it is an expression of the choice of rules. Indeed, facing to the possibility of ordering human coexistence by means of the exercise of naked violence or arbitrariness, the opposite option is the one of rules, of resource to models of behavior endowed with a minimum of stability, generality, and publicity. But, it could be said, the new normativities also implies resource to rules in the ordering of behaviors. Why then this concern about the death of law, when we remain actually in the scope of rules, which is what matters? But what is important is the relationship established between the rule and human freedom. Here we can differentiate between two models. First, normative ordering supposes the elimination of the freedom of the individual regarding the rule itself. The model of behavior is compulsory, but non-compliance is impossible. Second, normative ordering does not eliminate the possibility of non-compliance, since such compliance is one of the options available to the individual. In fact, behind these two models, there are different versions of the human being and his position in the framework of a model of social regulation. In the first case, the elimination of disobedience, understood here as a mere factual option, is admitted. In the second case, the possibility of disobedience is considered. Through disobedience to law, the opposition of the individual to the mandate is expressed. The critical dimension of the citizen is made explicit. Disobedience can provoke or dynamize the transformation of the system, evidencing, putting clear, its injustices. Thus, there would be a difficulty in reconciling some new forms of normativity with the critique of law and its transformation. In the end, the new forms of normativity can contribute to eliminating, partially, the problem of uncertainty and insecurity, at least regarding compliance or not compliance with the rules and the emergence and management of conflict. The rule will be obeyed because the opposite is impossible. It is the only option. But all this with the cost of limiting the autonomy and self-determination of the individual. At the same time, they reduce the possibility of criticism and opposition, of disobedience in the end. This reduction implies a restriction of the freedom of the individual and has the risk of leading to an impoverished conception of democracy in which the limiting instruments that oppose power and its technological expression are reduced. The challenge brought up by the new normativities is undoubtedly stimulating, because on the one hand, there is a standardization of human behavior that leads us to think about a too perfect citizen in correspondence with this perfect law of assured effectiveness. On the other hand, they allow us to reflect on whether a normativity of impossible non-compliance can still be considered a true normativity, or whether it is more like an announcement of what is going to happen in a very similar scheme to that of one norm of nature, far away, therefore, from the law we know. Thank you very much.